Celia Ashton. I've been asked to evaluate the Priceline Terms of Use Agreement. Priceline is best known as the website for finding deals on travel-related purchases such as flights, hotels, and car rentals. Terms and Conditions is a page on the website which sets out the rights and responsibilities of anyone using the site. This forms a contract between the user and the website. Legal disputes between the user and the site will be assessed based on these terms and conditions. Part 1 of Priceline's Terms of User Agreement deals with legal action. It details in arbitration and dispute resolution, disclaimer of warranties, general limitations of liability, indemnification and chargebacks, trademark and copyright notice, and claims of copyright infringement. Is it a valid contract? While Priceline contract is a legal valid contract, it is not a user-friendly contract. In AT&T Mobility vs. Conception, the court held the Federal Arbitration Act, which preempts state laws that disallow class arbitration. However, the demand for an arbitration-only dispute resolution places the consumer at a disadvantage. Arbitration blocks consumers from banding together in class action suits and favors the big companies in 93% of their claims, minimizing the number of disputes through clearly worded user terms and responsive customer service will reduce the need for arbitration and improve Priceline's reputation. Are visitors automatically bound to it, or should they have to click I agree? Currently, Priceline's user agreement relies on a browse wrap agreement. That means that users are assumed to have agreed to Priceline's terms just by browsing the site. Generally, courts have declined to enforce browse wrap agreements because the fundamental element of consent is lacking. In Nugent vs. Barnes & Noble Incorporated, the critical question was whether Nugent consented to the terms, specifically the arbitration clause. Nugent had neither clicked the hyperlink terms of use nor read them. Although Barnes & Noble argued that their hyperlinked terms of use were sufficient notice for anyone familiar with basic internet skills, the court did not agree. I propose that Priceline adopts a click wrap agreement, meaning click to accept terms of use before gaining access to Priceline services. Unlike browser wrap agreements, courts have routinely upheld click wrap agreements. The enforceability of these agreements turns not on the label of the click wrap, but rather whether the party had constructive notice of the terms of the agreement and disagreed to be bound by them. The click box to accept terms should be easily located on every page of the site to make it more likely to ensure enforceability. If you have a dispute with Priceline, can you sue them? In the case of a dispute, although the user agreement says the only venues of dispute are arbitration and small claims court, Priceline can be sued. The user agreement states that disputes must be resolved based on arbitration through the American Arbitration Association or small claim courts, and that all actions shall be governed by in the state of Connecticut. One example of Priceline being sued is Tersley Investments Limited versus the Priceline Group Incorporated, filed in Connecticut Superior Court. Tersley claims that Priceline defrauded them in connection with a $550 million acquisition of an industry competitor. Another example, Chapman vs. the Priceline Group Incorporated, was filed on October 10, 2015, in the District of Connecticut, and alleges that Priceline does not honor its best price guarantee promised on tickets purchased for travel on Spirit Airlines because Priceline secretly adds its own markup. Although Priceline filed a motion to dismiss, Judge Chattigny of the United States District Court for the District of Connecticut denied the motion. What changes would you recommend? I recommend that Priceline switches to a click-wrap agreement, with the agreement be worded to be understood by the average user, and that forced arbitration be removed for a more consumer-friendly resolution strategy. Thank you for listening.